Be ready. Start. Learned counsel for the respondent, on the other hand, contended that there is no apparent error in the judgment of the High Court in quashing the criminal proceedings on the ground of limitation. The High Court has correctly treated the handwritten notice sent by the appellant on 20th April 2020 as a valid notice in terms of Section 138 of the Act, as the appellant had given the notice in writing within 15 days information, being aggrieved by the judgment and order so passed by the learned single judge, and the landowners are before us in these appeals. We have heard Sri Gil Singh and Sri Pawan Kumar, learned senior counsels appearing appellants, and Sri Gil Singh for the learned counsel for the state. The learned single judge in the impugned judgment and order has not awarded interest on the said amount. We are or the that in view of the Constitution Bench decision of this court, the learned judge ought to have grants interest on the said amount. In view of the above discussion, we allow these appeals modify the order passed by the learned single judge and remit these appeals to the reference court to determine the compensation payable to the landowners in the light of the judgment and order passed by us in these appeals. We further direct the reference court to complete these exercise as early as possible, at any rate within higher limit of 6 months. Para. The primary question for consideration in all these appeals is whether the respondents were entitled as of right to one more opportunity to switch over from the contributory provident fund scheme of which they were members to the pension scheme and the general provident fund scheme implemented by the appellant with effect from 28th November 1988. Broadly speaking, the contention of the respondent is that they were aware of the switch over option since they were posted in remote areas of Punjab, while the contention of the appellant is that a large number of opportunities extending over 8 years were given to the respondents to exercise the switch over option, and that they could not claim any right to any further opportunity to make the switch over, being aggrieved by the decision of the learned single judge. The board preferred writ appeals before the division bench of the High Court. Para. The Act contemplates speedy and effective remedy but takes care to mandate compliance with the principles of natural justice and rendering of decisions after considering the evidence on record. The Act fully ensures procedural due process. The opposite party is heard, evidence is considered, and finding is recorded only after inquiry. In early complaint relating to medical negligence, as a general rule, it cannot be said that comprehensive evidence, irrespective of the nature of questions thrown open, must be brought on record for recording a finding as to the alleged negligence. If the questions raised are simple and do not warrant evidence, the same must be decided by the consumer redressal agency. But if complex questions are raised necessitating elaborate evidence of a highly technical nature and examination of witnesses, especially expert witness, is going to be a time consuming process. The redressal agency will have little choice but to ask the parties to approach the regular civil court for adjudication. Anything more than this we are not inclined to express. It is neither possible nor appropriate to lay down any specific guidelines to categorize complaints for expeditious inquiry under the Act and adjudication by ordinary civil courts, whether damages are awarded by a civil court for medical negligence or damages in the form of compensation are awarded by a consumer redressal agency. Stop.